Hello and welcome to Rights and Recourse, a program that tackles issues affecting your rights and matters of legal recourse. My name is Dumile Matez. Remember, you can also be part of our discussion by tweeting us at Rights Recourse or calling our studio line 011 714 5497 or 5498. You can also SMS your views by sending the word recourse to 34025. Alternatively, email your thoughts to rightsandrecourse@sabc.co.za. People often think the illegal downloading of material online, games, films, music, and books harms no one. But the truth is that there is a victim involved, and this is the original creator, the composer, the author, the designer, the filmmaker, and those who put in the resources to create the work. That is why South Africa has joined many countries around the world and have taken a stand to curb the proliferation of piracy, counterfeit material, and illegal downloads. But first, let's have a look at this insert.
Because maybe a dream that never lands is better than a dream that lands and crashes.
Hard at work. Many artists like this one are known for struggling to make ends meet, often dying without a penny. This despite the amount of wealth their work generates. But often this money lands into other people's pocket. This is the life of an artist, the musician, the painter, the author, and the filmmaker, amongst other things.
It's very disappointing. It's very discouraging because it's like literally taking somebody's food off the table. It's literally stealing somebody's salary. It's just that people don't see it that way, but that's exactly what it is. You know, some people get paid every month, they get the normal salary, but that's how artists earn. So when you pirate these sort of CDs, people don't get what they are supposed to get. And a lot of our musicians, they die paupers, they die poor, you know, and you're surprised, but these people, they're all over the media, they're on every radio station, they're on TV, they're everywhere, and yet they're not able to make ends meet, and you really get surprised why, but it's for simple reasons like this.
The advent of modern technology has exposed their work to piracy, plagiarism, illegal duplication, robbing them of their fruit of their hard work. While many countries have tightened laws and turned the heat on piracy and unlawful copying of sale of artistic work, South Africa is still battling to eliminate the problem. Piracy is not the only thing robbing the originator of their hard work. The counterfeiting of products is also a lucrative business crime syndicate have taken advantage of.
Is there unauthorized copying of music recordings? Even one CD, you are committing an offense, and you can be charged, and if convicted under the Copyright Act, you can be fined for the second offense 10,000 or 5 years imprisonment, or both.
If you go like down the road, there's people selling it next to the road. If they stop and they can confiscate the stuff right by the guys now and then.
The internet has also made it easy to illegally download books, software, and other products online. But to many, it never crosses the mind that downloading books, music, films, and other products online deprives the original producers of their livelihood. Lost income through piracy, illegal downloads, and counterfeit products is estimated at several millions of rand per annum. It is hoped that sustained campaigns through harsher legislation, policing, and public awareness will protect the rights of the originator. Mbali Madigwa for Rights and Recourse.
First of all, I'd like to point out that Opa Maloy, who appeared in that insert, according to David du Plessis here with us, passed away at the beginning of this month, and we would like to say, may his soul rest in peace. We're not aware. Joining us for today's topic are Ms. Monica Newton from DGG, from the Department of Arts and Culture, Promotion and Development. Mr. David du Plessis, CEO of South African Music Performance Rights Association, and at our Pretoria studio, we are joined by Mr. Herman Bluchnout, from a partner from Spoor and Fisher. Gentlemen and lady, good afternoon and welcome to Rights and Recourse.
Good afternoon.
Good afternoon.
Herman, let's start with you. Probably one should ask, what is intellectual property and is it tangible?
I think that's a good starting point, Emile. Intellectual property is an umbrella term which is used in relation to different forms of rights which are protected, which can subsist and have a definite monetary value. I think for purposes of today's discussion, copyright is probably the first and foremost form of intellectual property. And copyright subsists in different types of works, in total 9 works, which are all provided for in terms of the Copyright Act. It include works such as literary works, musical works, artistic works, films, sound recordings, computer programs, and so on. Now, trademarks, on the other hand, are insignia, symbols, and logos which differentiate one company's or undertaking's goods or services from those of its competitors. And again, you sit here with albeit an intangible asset, which could have enormous value. It's been said that in recent times, the most important, most valuable assets are not those which you can physically touch, the buildings around us and so on, but the intangible assets, such as trademarks, and that a company such as Coca-Cola, for example, were to lose its entire infrastructure overnight, but could retain its name, Coca-Cola, that it could, in a very short, quick space of time, get the business up and running again, and get on with business. Now, in addition to copyright and trademarks, you get patents, which are in essence innovations, inventions, designs, which really protect the eye appeal that a specific model might have, whether it be functional or aesthetic. And then there are other forms of intellectual property right which are not protected by statute. And these are things like trade secrets, confidential information, know-how, and so forth.
Why should intellectual property be protected by states or by statute?
Well, the important thing is that if you look at the sources of South African law, that South Africa specifically has as its first source was the Roman Dutch law. Which after some time with the English influence and colonialism, English law also were affected by South African law. But in recent times, and this is really where intellectual property had its birth, much more in recent times, that the lawmaker of a country, being our parliament, is tasked with protecting certain rights, such as intellectual property rights, and that it does through drafting and promulgating laws such as the Copyright Act, Trademarks Act, Patents Act, and so forth.
That name again looks like the elephant in the room is copyright law, and probably we should say on October 1962 a man by the name of Solomon Linda, a singer and composer of Imbube, died without receiving royalties for his work. And what about that copyright?
I had the amazing privilege of working on that case, so I know the background. It was an absolutely fascinating case. The important thing to note is that the Copyright Act that applied at that point was the 1916 Copyright Act, which was really the
which
1911
was called the Imperial Copyright
of the British Act. That's correct. That's correct. Now, that act specifically made provision for a reversionary right, a reversionary interest, which meant that although Solomon Linda had assigned his copyright to a publishing company or to a recording house
for 10 shillings,
25 years after his death, the copyright had automatically reverted to his estate, which was what that act made provision for at the time. It must be said that the current Copyright Act doesn't have similar or equivalent provisions. So it's not something that people can rely on at this point in time. But that because the copyright had reverted back to his estate, albeit 25 years after his death, an executor was appointed to his estate, which then sought to enforce the copyright which had reverted back to his estates. And through that, settlements were reached with companies such as Walt Disney, David Gresham Records. The terms of that settlement were confidential, but the important thing is that the family indeed had the opportunity to benefit from their father's work, the song he had authored.
There should be many, David, people who compose music, compose things in South Africa who didn't get nothing for it, no royalties for it.
Well, I don't know whether one can just assume that there would be many of them that did not get any royalties for their works being exploited. One would have to look at every single individual case, because this is also an individual case, the one of Solomon Linda. So whether they got everything that they were supposed to get, that is one question. Whether they were entitled to get more, or whether they were paid exactly what they were supposed to get, that depends on the circumstances and facts of every case. So I think it would be dangerous to draw a general or make a general assumption that people did not get paid. So one needs to look at individual cases on a case-by-case basis.
Mr. Newton, we've seen on numerous occasions we've been burying artists dying as paupers, and many people have said this has to come to an end.
Agreed. One of the complexities is exactly the term exploit. Because to have a right is one thing. To generate a royalty from that right means that that right needs to be exploited. So the work needs to be performed or sold or exhibited or transferred in some kind of way. And so that's one of the most complex areas that we're looking at the moment is, are we all well informed enough about this incredibly complex area of law, which, as Herman had pointed out, reaches back through time to touch multiple generations? So are we as artists looking at intellectual property, in fact, as an almost endowment of what we will leave to our families, and managing it accordingly to ensure that this kind of thing does not happen? But from the perspective of the Department of Arts and Culture, what we recognize is what is absolutely essential is to build a vibrant and robust market for local product so that those rights can be exploited. And equally ensure that artists are informed about their rights so that they don't necessarily assign rights inappropriately or are not aware of the rights which are theirs as they go into contract negotiations with recording companies, publishers, or other very important stakeholders in the value chain.
But let's ask David this. Recording companies have been accused of exploiting artists.
Well, one would once again have to adopt an approach of saying the circumstances of a particular case. But I would just like to go back to the point of artists dying as paupers. There's of course not a monopoly that artists would have on dying as paupers, because as a general rule, if your expenses are going to consistently exceed your income, you are going to die as a pauper even if you're a brain surgeon. So there is nothing unique about that. One would then need to look into why is it that these people are at a higher risk. One of the reasons would be that if you are only going to be a performer and you're not also a composer, and you are not running your business, which is the business of making music, as a business, you are going to run into difficulties. Because if you are going to be appealing to a teenage market, that may last maybe for 5 to 10 years. That does not mean that you're going to be successful like you would be if you follow some course in whatever and study for 4 or 5 years and then work until you're 60 years old. So there are risks involved in this line of business, because you are ultimately dependent on public taste, which is not something which can be predicted as an exact science. So there are high risks involved. So I would think that there is much that one can do, and from the record company side, the Recording Industry of South Africa, which is a trade association of record companies that's got almost 3,000 members, they have a code of conduct. So any artist who feels that their rights are not treated in the manner that it should be must go and have a look at the RISA code of conduct and see whether the record company is a member of RISA, and if they are, whether what the record company is doing is in breach. So all those inquiries must then just be addressed to the Secretariat of RISA, and they would look into it.
Well, you are watching Rights and Recourse, and if you would like to join us in today's discussion, please call us on 011 714 5497 or 5498, or tweet us at Rights Recourse. You can also email us at rightsandrecourse@sabc.co.za. We'll be back after the break. welcome back as we explore this issue of intellectual property and copyright. Herman, we've got an SMS that came in. You remember earlier in our introduction we spoke about downloading. The SMS says, how do I know that I'm downloading something that I have to pay for online?
I think probably the point of departure should be that when in doubt, you would probably have to pay something. What the internet has done is to make the infringement of copyright protected material so easy that there are ways and means of doing it that you can with relative ease download protected material without having to pay a cent through tools such as torrents and so on. The fact of the matter is that copyright subsists in the case of literary works, artistic works, for a long period of time, which is generally 50 years from the end of the year in which the author died. In a case like sound recordings and films, it's for a period of 50 years after the film was first published. So you are talking about a good period of protection which is afforded to these, for as long as you fall within that term, you would, for any reproduction or copy or download of that work, need or theoretically have to pay something. If you don't, it means that the rights holder simply gets nothing, to what they should be entitled to.
The other thing that concerns me, David, probably I should go to David with this question, is how do you decide when I'm a drummer, the other one is a flutist, the other one is a guitar player. How do you decide who gets what in royalties?
Okay, one would have to draw a distinction between royalties that are payable in the particular instance for making that particular recording at that time, where people may be paid a once-off fee as playing as a drummer, if it's basically a featured artist. There's another thing called needle time, which is the performance rights in sound recordings, which is the right of broadcasting, diffusion, and making it acoustically audible to an audience. Now, in that instance...
What do you call that, needle time?
That's called needle time, yes. So it's a collective term for those three rights, basically. Now, in that instance, one needs to look at the Performers Protection Act. Now, the Performers Protection Act does not specify or does not distinguish between a session musician and a featured artist. However, it does say that if somebody plays a significant role in a recording that has been made, that person would qualify to be a performer in terms of the act. Now, unfortunately, it's not made easier for us then where courts have had to consider what does that actually mean. So in instances where, for instance, British courts have had to decide, is it a qualitative or a quantitative test? So is it a case of the drummer playing on 10 tracks or some big name saxophonist playing on one track? What is the test that should be applied to say, is this person playing a substantive role? And they said they can't say. So that is a question which would have to be dealt with in the performers chamber of SAMPRA being the collecting society for performers and record companies, for them to decide in that chamber, not for record companies to prescribe to them or anybody to prescribe to them. It's for them to decide within that chamber how they want to deal with that question. Do they want to allocate a certain number once-off fee? Is it a percentage? What is it going to be? There are precedents around the world, so probably what's going to happen is that they would look at those instances where it has worked well and then follow something similar.
Monica, I'm a musician. I don't know all of these things around copyright and intellectual property. I only make music. And it so happens that you only get to understand these terms if you're studying law at university. Whose role is it to explain to or to educate the artists and the musicians as to these kind of things?
I think it's a dual role. So for one, if you're wanting to be a professional musician, I would imagine that you would also see it as your role and responsibility to learn as much as possible about the industry that you're in. And you've also selected one of the most complex industries to be a part of, so you need to get those books open. But It is equally true that organizations like SAMRO, the rights administrators, actually do have extensive education programs. There's a lot of information available on the internet, but it is certainly true that with regard to the education that your average artist receives, for example, at university or in community structures, intellectual property is generally not taught. And I think that that's one of the problems. Because in essence, we need people like Herman and David to interpret the system for us, but in order to even ask the right question, we need to understand our own rights. And so it starts with the question, as David had pointed out, as a musician, who are you? Are you the composer? Are you the lyricist? Are you the performer? Are you all three? Are you the producer? So there are a lot of questions that artists need to ask themselves as they begin to make their careers in this very complex area called the creative industries.
Before I go to a question about the collecting societies, I want to ask this question. Herman, you and David can probably share the question. There's been a proliferation of piracy over the last couple of years, or over a number of years, and musicians are up in arms with this thing. Who should be policing the piracy, both in terms of music and also in terms of clothing that has been patented?
Yeah. Well, if you talk about policing, there are various agencies, whether it be public and private, involved in attempting to police, and embark on this battle against piracy. If I may take one step back, you get different forms of piracy, and if I might quickly touch on these, it's essentially source piracy, where a person could, for example, sit in a movie theater, a cinema, and with a camcorder or even a smartphone these days, record a new release, the hottest, biggest release of the month, and within a matter of hours have that movie on the internet available for downloads. Hard goods is at this point, I think, generally considered to be South Africa's biggest problem, where you have street vendors, retailers, and online retailers selling counterfeited products. And then, as we intimated earlier, online piracy, where you have, through the use of torrents and so on, the capability to download protected material. Now, each of these have its own agencies, which really should look after them. But the starting point is, who is the rights holder? Because it is only the rights holder that is in the position to take steps to enforce its rights. Now, the rights holders will generally cooperate or collaborate with agencies such as their lawyers, and then people like the Films and Publications Board, SAFAC, the South African Federation Against Copyright Theft, to see what is the specific problem and how is that addressed. Because each of these agencies have their own mandates. But I think to answer your question, it is the rights holder. We must take the initiative, because effectively that is the only person entitled to.
Well, David, that's exactly what the musicians are doing. They are running around chasing people who are pirating their CDs. What's the industry doing?
Well, RISA, that's the trade association that I mentioned earlier, of which OPA was an operative at the time, used to have its own in-house anti-piracy unit, but has subsequently joined SAFAC and is then paying a membership fee to SAFAC, and through SAFAC that is happening. But one thing that I read on Friday was, I think that the total combined loss incurred by the entertainment industry in respect of movies, films, broadcasting, etc., with illegal copies being made of what is broadcast, apparently amounted to $800 billion last year, which is a huge chunk of money. Now, when people think about piracy, they might think that, well, that guy driving in the flashy car doesn't actually need the money. But only 1 out of 10 albums that come out actually break even. It is estimated. So it is that one album that is actually subsidizing the other 9 to be brought out. Now, it is not a model that can just continue if people think that they can buy a pirated product and there are no repercussions or implications, because every time that you buy that, I mean, you are essentially stealing from somebody, and it is theft.
The question I also wanted to ask earlier was around the collection of these royalties. Who are the collecting societies? Who have been entrusted with collecting the money? Because surely I can't expect the musicians to be running around collecting money from those who are using their work.
Okay, maybe one must just first draw a line, like there's a line in this table, maybe the viewers can't see that.
But there is a line in
there
this
is a
table.
line. There's
It's not a
definitely
line in the sand.
There's a very
And
clear
I'm
line.
straddling it. Yeah.
So if just, or let's say if this is the only thing that viewers take away from this program as far as the various rights are concerned, that would be good. You have to separate the composition from the sound recording, because there are copyrights in both. When it comes to the copyright in the composition, you have the so-called performance rights in those. That is administered by SAMRO. So whenever a composition which is in copyright is broadcast, diffused, or made acoustically audible, that is administered by SAMRO. If you are going to make a reproduction of that composition, the organization which is going to deal with it, which is a new organization called Capasso, that's who you have to talk to. Moving across to the sound recording side, the performance right in the sound recording, that's dealt with by SAMPRA, S-A-M-P-R-A.
Of which you are the CEO.
Of which I'm the CEO. The mechanical rights or the reproduction rights in the sound recordings are not dealt with collectively. That is something where you would have to approach individual record companies for the authorization to have tracks reproduced. So who have I not mentioned? Norm. That is a
Norm,
trade association of music publishers, just like RISE is a trade association of record companies. So you've got collecting societies and you've got trade associations. Some deal with musical works, others deal with sound recordings. So that is the most important thing that people just need to bear in mind where that falls in. Another thing, of course, is that royalties are payable by record companies and by music publishers for the exploitation of sound recordings and compositions. That is something which is not dealt with through a record company. So if I record for a record company, my own record company or somebody else, and the CD gets sold, then I will get paid in terms of my contract, and there will be accounting of royalties, not through a collecting society, but through that record company for the sale of CDs.
Well, when we come back, we're going to take and see what the Twitter community is saying around this issue. But if you'd like to call us, you can call us on 011 714 5497 or 5498, or tweet us at Recourse. We'll be back right after this.
Diwani has pleaded not guilty to murdering his wife. In November 2010, Diwani's murder trial finally got underway. It's taken South African authorities more than 3 years to get him into the dock.
Not guilty of robbing, kidnapping and murdering his wife. This is how Diwani pleaded before Deputy Cape Judge President Jeanette Traverso.
Why did these two men need even a gun to scare a little girl like that? Those are the questions that runs around our head.
Your World, weekdays at 9 p.m.
Well, welcome back, and let's have a look and see what the Twitter community is saying around this issue. Mapena says, even if we copy a whole book, our resources are inadequate. That's justified. And then Deja Vu says, South Africa follows a directive into intellectual property that the European Directive of Intellectual Property, and we all other bodies are governed by this in this area of law. And he also says we pay a copyright fee for photocopying text. We don't photocopy the whole book. Herman, probably let me go to you. The protection of literary work. How is that done compared? I see there are a lot of problems in music. How is that done compared to what we're talking about music?
Yeah. There is generally a misperception when it comes to literary works, such as books, textbooks, and so on, that people are allowed to copy 10% from this book without having infringed copyright. Some people use other percentages. The bottom line is there is no such percentage that exists. So when you copy a book or a substantial part of that book, you are potentially treading on dangerous grounds because that could constitute an infringement of copyright. But, and this is a very important but, is that the Copyright Act makes provision for a defense against a claim of copyright infringement referred to as fair dealing or fair use. And in terms of the Copyright Act, it is permissible to make a copy of a literary work, a musical work and an artistic work for personal and private use or purposes of private study. Now, the Copyright Act doesn't limit the copying of that literary work to 10%, 15%. Theoretically, you could copy 100% of a book, with that conduct then falling under the ambit of fair dealing.
A colleague of mine, before you go, I just wanted to add this to that. A colleague of mine told me recently that students gather together and they buy one set of books and they make copies for all the others without having bought the books themselves.
Yeah. Conduct like that is not easy to answer, easy to say what the results could be. If I have to add my 2 cents worth to say that, I think that is problematic, because the moment that you buy a copy and you make you make multiple reproductions thereof, the syndicate is now teamed together and they've got one copy between them and they start making multiple reproductions. I think that exceeds the ambit of fair dealing. That it's not just simply more one copy for your own personal and private use, but that through your conduct and of course depending on how big the syndicate is, you are materially or potentially affecting the monetary interests of the author.
The other one is here next to me, she admitted. Monica admitted that she's done that before.
I was an impoverished university student.
But as I said earlier, I think as a student, if you copy a book, and I don't want to step on anyone's toes here, but there is always the issue of fair dealing. And I think as a student, if you make a copy from a textbook, in appropriate circumstances, even an entire textbook, that your conduct could be protectable as fair dealing, and it wouldn't constitute copyright infringement.
David, you wanted to say
bearing
the way
in mind that it's a single copy.
Yeah, sorry, I just wanted to comment on that. Just in the first place, there is a distinction to be drawn between fair dealing and fair use. Fair dealing is something that you find in South African legislation. Fair use is something that you would find in US copyright legislation. Now, a common error that people make is to simply assume that what applies in US copyright legislation somehow it applies around the world. It doesn't. So the doctrine, if you want to call it that, of fair dealing and the doctrine of fair use are completely different. The one says that I'm entitled to actually make a private copy for personal use. The other one says that you are limited in what you may do. Now, when it comes to students and the copying of textbooks or extracts from that, as somebody with children at university, I know that as part of the student fees, there is a fee that's payable to Dalro in respect of the reproduction of...
What is Dalro? One of those...
It is a full subsidiary of SAMRO, but it deals with literary rights. So what they would do is that they actually license usage by universities where copies are made beyond the scope of fair dealing. You would then pay a license fee to Dalro in order to do that. So when we talk about fair dealing, is about where you are limited, that you may not make use of a portion which is going to impact negatively on the commercial viability of that work. If you are going to make a copy of the entire work, clearly you are going to impact on the viability of that particular work. If you're going to take a page, it may be 2 pages, but it is always going to be a test that you would have to apply on a case-by-case basis. Because if I write a book with 12 pages, making 2 pages or copying 2 pages out of a 12-page book is probably going to exceed what would be reasonable. So one must just be careful about what the test is that you apply, but also bear in mind that universities are already paying, in many instances, for the reproduction of literary works.
Herman, I just want to go back to something else raised by Deja Vu, and that is South Africa follows the EU directive to intellectual property. Is that the case? Because I've known in our trade discussion with the European Union, we were at some stage told we cannot use words like port, Cabernet Sauvignon and others, liqueurs that we celebrate in South Africa, that we enjoy.
Yeah. I think it's incorrect to say that South Africa follows the EU directives. South Africa has its own laws relating to copyright. That's the laws that apply in our land and that we must follow. Although South African laws are to a great degree based on and harmonized with international intellectual property laws. So there is good overlap between them. Apart from the actual laws that apply in our land, South Africa is, as a member country, party to various bilateral and international agreements.
Include the WTO.
And that's correct. I mean, we are a member of the World Trade Organization, and by virtue of our membership, we had to adhere to certain of their very basic requirements relating to the protection of IP in South Africa. Now, to get back to your question on port and feta and champagne and so on, these are all terms which are classed as geographic indicators. And South Africa is a member to an agreement that respects these as geographic indicators in a similar way as other countries have acknowledged that, for example, rooibos is a geographic indicator of a specific area in the Western Cape in South Africa. Now, by virtue of this, that champagne being acknowledged as a geographic indicator of the region Champagne in France, you may not make sparkling wine in South Africa and call it champagne. That is really the effect that it has.
Thank you for that
explanation. In
explanation.
South Africa, you can't make port and call it port. It's a fortified wine because port is from Portugal.
Thank you very much for that explanation. I didn't really know why we were not supposed to use the word port. Now I know. David, the one other thing that the issue of copyright has probably led to the growth of music composed specifically for films.
Yes, I think that to the extent that the South African film market has grown, there would be a demand for people to compose soundtracks for those. But that brings us also to the point of international treaties where sometimes they work in one's favor, but then there are instances where we actually need to enter into treaties in order to get the kind of protection that our artists actually need in the rest of the world. So for instance, there are things like called the internet treaties, the WIPO internet treaties. Now, by virtue of the fact that we have not yet acceded to the WPPT and the WCT, which are the two treaties, our own performers are in fact not protected when they go abroad. Now, what appeared to have happened is that the Department of Trade and Industry have introduced elements of those treaties into our legislation, but they didn't actually become a signatory to that. The problem that then creates is that the test that is applied by other countries to see if they're going to give protection to our performers in their recorded acts wherever it may be broadcast is not dependent on a substantive analysis of what our legislation provides for. It simply looks at to see, is this country a signatory, yes or no? No, it's not. No, we don't grant protection, which is rather unfortunate because that is actually a little thing that we can do to actually ensure the livelihood of our artists when these things happen abroad, including what you just mentioned when it comes to soundtracks. Because in the United States, for instance, for movies like Tsotsi, not a single cent of royalties for when that movie was played in a cinema came back to South Africa because they don't have the right, they don't acknowledge the right to collect in that country, whereas they wait for the rest of the world to actually pay them for all the movies that emanate from America, which is of course quite unfair if you think about it.
I think you guys should sort that out with the Department of Trade and Industry, including the Department of Arts and Culture.
Indeed. The multilateral agreements are obviously enormously complicated, and they operate at a level that generally in some cases is not only specific to the creative sector. So it requires a great deal of analysis to make sure that the implications are considered broadly and not just narrowly in every respect. So it is a very long and complex process, and we have very skilled negotiators who sort these matters out for us. But as has been pointed out, this is the lead department in this case is the Department of Trade and Industry.
Herman, let me go back to you. Herman, why is it so difficult to manage the system when it comes to music? Probably David will join you there. But if I buy broadcast rights for an event, I pay for that event, and it's only me who's going to be able to show that event. If I buy, for instance, broadcast rights for the Cricket World Cup in Australia and New Zealand, it's only me in this area for Africa who's going to show that cricket and nobody else. Why is it so easy to manage it at that level? It's so difficult to manage it from a music point of view.
Yeah. Music and songs fall under copyright protection, as we've established, and copyright law is generally considered to be a technical field of the law. Now, if you dissect just what lies in a song, you've got the lyrics, which is protected as a literary work. Apart from the lyrics to a song, you've got the actual music that forms part thereof. So if you look at what a song consists of, it is actually a collaboration, or potentially a mixture of two protected works. So on the one hand, there is the writer of the words, the lyrics, that would want its piece of the cake. And on the other one, there's the composer of the music. So you can see already it's starting to get technical. Now it depends on what you want to use the music for, in which way do you want to use it. And you have to get the necessary permissions from all the rights holders or their representatives, such as copyright collecting societies. And they want to know generally, how you want to use it, how many times you want to use it, and so on, to ensure that in the way that the song is exploited, there is sufficient remuneration made for that to be channeled through to the rights holders in the form of royalties. So maybe this is an appropriate juncture to let David in on how they would generally deal with it in
David,
practice.
just throw the ball into your court.
I think that part of the issue for people who don't deal with it on a regular basis is that you buy a CD and you think, well, this is just one thing. Okay, but you do actually involve a composer, a music publisher, a record company, a performer, not just a performer, but a multiplicity of performers, all forming part of this thing. So it could be that is recorded by a small independent label and it's licensed to somebody else. So lots of parties play a role. So from the user's point of view, it seems to be obvious to say, well, I would like a one-stop shop. When it comes to cricket, it's quite easy. I mean, it is not as if you have to negotiate with every single player on the pitch as to what you're going to pay them. You talk to Cricket SA.
Forever.
And so that is why it is easy, because I mean, you can talk to one party only, but when it comes to music, you can't. But I mean, in as much as one can understand that there's a need for a one-stop shop, it is almost the same as expecting to say, I want all my accounts, whether it is for clothing, telecom, television license, all of that. I just want to get one window envelope every month and I will pay that. Well, it will make your life a lot easier, but it is not necessarily very practical for all the other people who do not all sit around the same table, don't serve the same interest, to say that because in the perception of a user they're all the same, therefore they should just all combine.
Well, if you still would like to join us, you can phone us on 011 7145 497 and 5498. And for the time we have left, I'd like us to talk about, after the break, the indigenous traditional knowledge protection. And probably that's an area that Herman will help us navigate. Don't go away, we'll be back after the break.
In Africa, mobile devices are tools to make payments, browse the internet, and keep governments in check with social media forums.
It's given an average African too much power in their hands.
And tech creativity is solving some of the continent's problems.
Everything is internet driven.
And on Network, we tell you how Africans are using technology and social media in their everyday lives.
Join Siphumelele Zondi on Network every Sunday at 19:30 CAT.
Welcome back. You are on Rights and Recourse. Now, Herman, one of the things I wanted to talk about is apparently there is an traditional knowledge bill that is collecting dust somewhere in Parliament that has not been passed. And I wanted to talk about traditional things that we need to protect ourselves. You mentioned one of them, rooibos tea. And should these things be protected?
I think there's good reason for it to be protected. About the bill that's gaining dust somewhere, that's in fact not entirely accurate. The Intellectual Properties Law Amendment Act has been passed. And in terms of this act, there are certain amendments, not proposed, which have been made to the Trademarks Act, Copyright Act, Performance Protection Act, and so forth, whereby traditional knowledge, or in the case of copyright traditional works, are all now introduced as separate types of works that can be protected under the Intellectual Property Acts. The reason why the Act hasn't officially been implemented is that my understanding is regulations are yet to be drafted, and once the regulations have been prepared, been presented for public comment and so on, and officially passed, the Act will come into operation. But as far as the Traditional Knowledge Act is concerned, it's been passed by Parliament.
Monica, you had something to say around this bill.
Well, in essence, it speaks again to some of the complexities of the work. So there are a huge number of people in the government family who are involved. So science and technology is essentially where Indigenous knowledge systems rests. We play some role in the creative industries development. Trade and industry deals with elements of intellectual property and in fact is the custodian of intellectual property. The Department of Communications has authority over local content regulations and of course the broadcast environment generally. So it's the intergovernmental cooperation required to run a system of this nature is quite complex, and given the technical nature of these bills and of these regulations, they need to take time. This is a cake that needs a long time to bake because they're very technical, they have huge international implications, they generally have major business and financial implications as well, which is why they sometimes don't just run through parliamentary processes.
Herman, probably let's quickly, you mentioned rooibos earlier. What other things can be put under this act if should it go to Parliament, or probably under the act that you said has been promulgated?
Yeah. This act was passed despite much criticism from certain sectors of the trade. The idea was that the protection of traditional knowledge would be or could be much better accomplished through the passing of a sui generis act that was specifically aimed at the protection of traditional knowledge, not taking these provisions and throwing them into different IP acts and causing a stir where it perhaps didn't belong. But to get back to your point, or at least your question, is that examples, I suppose, could be applications which people have used with something like, for example, the hoodia plant that has eating suppressant effects that could have slimming results and so on, which I understand was used by local communities long before these actual...
A South African actually based in Switzerland, Andre Mayberg, actually sent an email to somebody in South Africa and said South Africa should begin to protect biltong.
Well, I mean, I would definitely be in favor of that. We are known for it. Whether that would fit in, I'm just not sure whether that's, if you consider the acts which could apply to it, it's not a copyright work, it's not a trademark.
And somebody mentioned Mampur to me. I said Mampur is another one that must be protected.
Perhaps the name, yes, you can, but the way it's distilled, not.
Well, you might see us laughing. There's still a lot of problems around these issues, especially in South Africa, especially in the music industry, David.
In what sense in particular?
In terms of music, in terms of copyright in the music industry.
Well, I think that there is a lot that can be done to change legislation to better provide for the people that are creating content, whether it's the composer, whether it's the record company and the performer. Because it is not necessarily a case of because the Act was promulgated, the Copyright Act in 1978, as if it has not been updated from time to time. So one should not get stuck into looking at 1978 because there's obviously been quite a number of changes since then. But there are many ways in which the Copyright Act could be amended to make it more applicable. In fact, to the kind of world. Well, yes, user-friendly also, but to make it more applicable to the world in which we live. So, I mean, in 1978 and for many years after that, the notion of an internet and actually diffusing things in that fashion or transmitting signals in that fashion is not something which everybody would have thought about.
Should these things be discussed at Moshito?
Yes, and in fact have been discussed at Moshito over quite a number of years because music was the canary in the coal mine in some respects for the disruptive technologies in the digital domain. And as a result, internationally there's been a huge amount of work, the Millennium Act in the US, and our policy environment is slowly but surely moving forward. And one of the major recommendations of the CRC, the Copyright Review Commission, was precisely to begin to engage with these areas head on because we are slightly behind the curve.
Well, that's it for today. That has been, the CRC has been a commission that was set up by the Minister of Trade and Industry, which was led by Judge Ian Fallon. Then we've come to the end of our program today. We've learned a new term, the canary in the coal mine. That is what music is. If you'd like, this is the end of our program. This has been Rights and Recourse. This program is repeated at 10 tonight and at 5 on Monday morning. From all of us in the studio, thank you to our guests. Oh, we're supposed to take a break. No, I'm actually in a hurry. I'm told we're supposed to take a break. Please don't go away. Stay with us. We'll be back right after this.
Cameroon's economic capital, a unique art collection is on display. Titled Yesterday's Memory, Tomorrow's Memory.
We are trying to preserve this heritage despite many things that have changed in the designing, embroidery and the model.
If I'm telling you, you don't like it, I call it defeat.
Join Musam Khalipi on Afro Showbiz every Saturday at 19:30 CAT.
Welcome back, and with all of these terms and these lot of things we've been talking about here, I've got a bit confused. But first of all, let me come back to the Review Commission. What was the Review Commission about?
Essentially, the Copyright Review Commission was established by the Department of Trade and Industry with a very wide ambit to look at specifically copyright. It's called the Copyright Review Commission, not the Intellectual Property Review Commission, but to begin to look at things like the operations pertaining to copyright collection societies, licensing agreements, beginning to think about digital and mobile technologies. And so over a very protracted period with 28 very detailed inputs from the sector, the CRC made a series of very wide-ranging recommendations pertaining to copyright collection agencies, the accreditation systems, amendments to Intellectual Property Act, and through the Department of Trade and Industry, a task team has been established, an intergovernmental task team that essentially combines all of the departments involved, communications, arts and culture.
And that's actually the committee that is supposed to pull all of these things we've been talking about together.
And essentially monitor the implementation of the Copyright Review Commission.
Is that possible?
Is it possible to do what?
To implement all of these things that are in this thick document.
The document has some good things, and there are some other things which are possibly not so good, and that's maybe just a subjective view. But there are parts of it which seems to be written by one person and then other parts written by somebody else. So there are elements of it which is good and which can be implemented. There are others where one would have to question what was extracted from whom to come to that conclusion. So it is not, in my view, an unqualified success, but I think there's a good foundation for things to be worked out. It is just that as it is, there are things there that could be questioned.
Probably let's go back to Herman. Herman, probably from your side, we have a rather positive parting note. What happened in the end to the Solomon Linda issue when you went to court? Please just let us into that with that story.
All right, well, to dig into a little bit more detail on that. When the executor was appointed to Linda's estate, it was then important to say, well, who were the potential infringers that could be taken to task? And there was a strategy planned around that to make the biggest impact with the least amount of work and cost to be incurred. Now, the Department of Arts and Culture, Arts and Culture, I apologize, was very much involved in that as a sponsor to the legal fees for Mr. Linda's family. So there was real support from their side as well. But when the strategy was embarked on, it was really to say, let's take on the Disneys of the world. You know, they had the Lion King film, there was the Lion King stage show, all of which featured part of the Lion King or the Lion Sleeps Tonight song. So it was decided that they would be taken on summons issued against them to sue them for copyright infringement and the payment of royalties. The challenge at that point was that Disney
probably, Herman, you should just go to the end. What is happening now around that discussion, that issue?
Well, the issue has been resolved. The parties that were sued had agreed to a settlement, and the settlement included payment of royalties, which was both royalties for past performances or uses of the song, but also future payments for the exploitation and the use of that song. And I believe that copyright subsisted until around 2012. So they would have paid up until the expiry of the copyright, which was
Thank you very much, Herman. That's exactly what we wanted to hear. I wanted to part on a positive note. This has been Rights and Recourse. This program is repeated at 10 tonight and on 5 on Monday morning. From all of us in the studio, thank you to our guests and good afternoon.